So yes, the Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning, gentlemen, and welcome to the Court of Appeals. I want to, first of all, tell you how much we appreciate you participating in these oral arguments via Zoom. It is, even though we've been doing this now for about a year, it's still a work in process, and at times we have technical glitches. So if we experience any technical glitches today, nobody needs to get too worried. We'll take care of it. We'll make sure that nobody is prejudiced by it and make sure that everybody gets their full allotment of time. But if you do experience a problem, be sure and let us know, and we'll move forward from that. Couple of things I want to do. First of all, I want to introduce your panels for today. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. The other thing I need to remind you of is that even though we're doing this via Zoom, the same rules and procedures apply. So please act as if we were in the courtroom today. And the same protocols will apply there. By that, and the same procedures will apply as well. By that, I mean each side will have 15 minutes to make its oral argument. If you are the appellant and you have previously reserved rebuttal time with our court clerk, Angie Dempsey, then you'll receive that time. And I neglected to introduce Angie, but she's with us, and she's the person, she along with the AOC Representative Kevin Jacobson, are making this possible for us today, and we certainly appreciate both of them. There will be a timer that will be evident for everyone to see, so you can keep up with your time as you go forward. I think that about covers everything. Angie, anything we need to take up before we get started?
No, Your Honor. All
right, you may call the case then.
Elizabeth Ann Sykes versus Chad Stephen Sykes.
We shall hear from the appellant.
Morning, Your Honor. Ben Lewis from the Rutherford County Bar on behalf of the appellant Chad Stephen Sykes.
You may proceed.
Thank you, Judge. Your Honors, this morning I have, on behalf of Mr. Sykes, we are presenting 6 issues, total issues for appeal that have been more identified in our brief. However, I would like to touch on them this morning. The first of those issues is whether the trial court erred in determining that it had jurisdiction over the party's divorce, subject matter jurisdiction. Likewise, we are appealing the decision of the trial court that it also had jurisdiction, subject matter jurisdiction, over the child custody determination regarding the party's minor children. We are appealing, and we feel that the trial court also erred in making its equitable distribution of marital assets and debts after the parties had already agreed upon the same and announced an agreement. Fifth issue is that the trial court erred in finding the appellant in contempt for violation. The fourth issue is that the trial court erred in finding the appellant, Mr. Sykes, in contempt for violation of a statutory restraining order and the trial court's order on August 16th of 2019 with an ex parte order regarding a minor child. The fifth issue is whether the trial court erred in awarding attorney's fees to the appellee as alimony in Solido. And lastly, whether the trial court erred in failing to provide the appellant an opportunity to question or challenge the attorney's fees that were granted. The first issue regarding subject matter jurisdiction, Your Honors, based upon the court or the ruling of the court and the proof submitted during both the hearing on the motion to dismiss and at trial, it's the appellant's position that the proof was insufficient for the court to find that jurisdiction over the divorce was appropriate in Tennessee. Pursuant to section 364104 of our Tennessee Code, either the acts leading to the divorce must have occurred in Tennessee while one party is a bona fide resident, or the acts were committed outside Tennessee and that one party resided in Tennessee for more than 6 months. It is undisputed in this case that neither party resided in Tennessee for 6 months prior to the filing of the complaint for divorce or the motion to dismiss being filed. Both parties.
Mr. Lewis, let me ask you a question.
Yes, sir.
Is it your position that there was not jurisdiction because neither of the parties resided in Tennessee for 6 months?
It is my position that there was not jurisdiction because while one party was a bona fide resident of Tennessee, the acts of the divorce did not occur in Tennessee.
I'm not sure what you base that on, because the complaint certainly alleges acts that occurred in Tennessee, and the divorce was granted on stipulated grounds. So, and the plaintiff was a bona fide resident of Tennessee. So I'm at a loss to understand your argument.
The appellant's position is that the trial court did not make specific findings regarding what acts occurred in Tennessee. While there were alleged acts in the complaint, there is no finding from the trial court as to what those acts were. Mr. Sykes contends he never moved to Tennessee to reside with the mother. He simply brought her property here and then returned to Missouri. So therefore, no acts could have occurred in Tennessee that would have led to the divorce.
Am I incorrect that the divorce was granted on stipulated grounds?
I do believe that Mr. Sykes came before the court the day of trial and agreed that he wanted to be divorced.
But did he stipulate to grounds?
I'm not. The record does not reflect that he stipulated. I don't believe it reflects he stipulated to grounds specifically. He just simply came before the court. The court asked him, does he want to be divorced today? And he said, I want to be divorced today.
And the court granted the divorce on stipulated grounds.
Yes, Your Honor. If his statement of I want to be divorced today was stipulated grounds, then yes, sir, it did.
Go ahead.
Thank you, Your Honor.
Well, let me follow up on a question that Judge Golden asked generally. It's your contention, I assume then, that you believe the court should have specified which acts it was relying on that were committed in Tennessee. Is that correct?
That's correct, Your Honor. The complaints makes very vague allegations of actions that occurred in Tennessee, but the record reflects Mr. Sykes' position was that he never resided in Tennessee. He simply came here to deliver property to the mother, and then he turned around and he still had a home in Missouri. He still had his job in Missouri. Everything was still ongoing in Missouri.
What does it have to do with what grounds occurred in Tennessee?
The position is that the grounds could not have occurred because he never came here. So the allegations.
Excuse me. You say he never came here? He was living in his in-laws' house at the time. He changed his driver's license. He changed his vehicle registration. He was living at the wife's parents' home and was served in Tennessee.
The record.
Am I incorrect about that? Did he not do those things?
He did change his license to Tennessee, Your Honor. I think he did stay at the in-laws' house for a short period of time, but he never moved. His position is he never moved to Tennessee.
But I understand you take the position that he returned to Missouri. What I don't understand is how that relates to whether or not there were grounds that occurred in Tennessee when they were alleged in the complaint that they occurred in Tennessee.
Yeah, yes, sir.
After he moved to Tennessee, while he was here in Tennessee.
Yes, sir.
He was never here in Tennessee. He was here in Tennessee, as I understand it.
Our position is that there was not a finding in the record of what those acts were and whether they actually occurred in Tennessee. Mr. Sykes' position is that any acts that were alleged to have occurred regarding the divorce had to have occurred in Missouri.
Okay, let's follow that train just a moment.
Yes, sir.
Did you specifically request the trial court to make those findings?
I was not Mr. Sykes' attorney at trial. Mr. Sykes represented himself pro se. I did not make a request personally for that to be found. I don't believe Mr. Sykes did either.
Okay. In other words, okay, Mr. Sykes was pro se at that period of time. He was self-represented. And to your knowledge, no request was ever made at the trial court to specify which acts it relied upon in saying Tennessee had jurisdiction.
That's correct, Your Honor.
Okay. Second thing, just to follow up on what Judge Golden raised, Mr. Sykes made the argument he was not a Tennessee resident, but it's my understanding and again, we haven't reviewed the record. We have reviewed, obviously, the trial court's orders, that the trial court found Mr. Sykes not to be credible. Is that also accurate?
That would be accurate, Your Honor.
Okay. All right. You may proceed.
And to circle back around to what Your Honors have questioned on, there was originally, when Mr. Sykes was represented from the outset of the complaint for divorce, he did file a motion to dismiss on these same grounds, that that there was no jurisdictional basis, and the court denied that motion. So that's really what we go back to, is that the court inappropriately denied that motion, which then he could not have then conferred jurisdiction by stipulated grounds. But I will move on to my next issue, which is the jurisdictional issue regarding the child custody portion. Similarly, Mr. Sykes, through counsel at that time, prior to counsel withdrawing, filed a motion to dismiss the complaint for divorce because the Tennessee courts did not have jurisdiction over the party's children. The trial court found that it was not the home state of the children. It also found that Missouri was not the home state of the children because the children had been absent from Missouri for approximately 2 to 3 months prior to the filing of the complaint for divorce. However, the trial court did find that because no state had a home state jurisdiction at the time, and that one of the parents was residing in Tennessee, the record is a little vague on this, but what I believe that the trial court found was that there was evidence in Tennessee concerning the child's care, protection, training, and relationships sufficient to then confer jurisdiction on Tennessee. What the court further went on to say, in accordance with Section 366213 of our code, was that it was going to communicate with Missouri regarding the jurisdiction and whether or not there should be some type of case going, because Mr. Sykes had filed a case in Missouri at that time as well for divorce. Ultimately, it is unclear. The court states that it were communicated with Missouri that was going to, but there's never a record made of that, which is required by the statute. The appellant argues that for the entirety of the party's marriage, with the exception of those final 2 or 3 months that Your Honors have identified, they resided in Missouri. The parties attended, or the children attended school in Missouri. They attended speech therapy even during the pendency of the divorce in Missouri. One of the children had an IEP established in Missouri. Therefore, the only evidence suggesting that there were significant relationships with Tennessee come from those final 2 or 3 months where the mother and the children moved to her parents' house here in Tennessee.
To the Missouri divorce.
Pardon me, Your Honor, I'm sorry.
What happened with the Missouri divorce? Is it now dismissed?
It was dismissed following the hearing or the resolution of the motion to dismiss, I believe.
The resolution of the motion to dismiss in Missouri, or the resolution of the motion to dismiss in Tennessee?
In Tennessee, Your Honor.
Okay. When the case in Tennessee was allowed to continue and the case in Missouri got dismissed.
That's my understanding, Your Honor.
Was it voluntarily dismissed by the father?
I believe so, but I cannot say for certainty, Your Honor.
Does that create a mootness issue if that case is no longer in existence?
You know, I'm not certain that it does, because this court can still review the determination of whether jurisdiction was appropriate at the time that the motion to dismiss was heard. However, I do understand the problem that Mr. Sykes faces from the fact that the children have now been present in Tennessee we're going on 3 years now since this divorce was originally filed. So I do understand the issues, because even if there was not jurisdiction at the time, there likely is now. However, it is our position that the court erred at that time in making that ruling.
If you are accurate in your analysis that the trial court failed to make a contemporaneous record of its discussion with the court in Missouri, what is the appropriate remedy?
My position would be the appropriate remedy on the entire event would be to make the determination as to jurisdiction at the time that the parties, that it should have been made on the motion to dismiss, but respectfully, I'm not sure what the exact remedy is for a failure to make a record, other than the fact that it prejudiced the father in regards to his arguments regarding subject matter jurisdiction at that time. And this court should then make the same determination. Your Honor, I'm out of time, I believe, so I will stop there. Thank you for your time.
All right, thank you. We will hear from the appellee.
Good morning, Your Honors. Jacob Thorington for Elizabeth Sykes, the appellee in this case. Your Honors, this case can be summed up if you look at Exhibit 11 in the record. There was a text message that Mr. Sykes accidentally sent to my client, Mrs. Sykes. And in that text message, when Your Honors review it, you'll see that he states he's going to go back to Missouri to, and I quote, rip the rug out from under her, and I end quote. That explains the entirety of this case. What you've seen is what the record will show as you go through this case is that Mr. Sykes has made the same arguments over and over again. He's been found not credible by Judge Woodruff. I was Ms. Sykes' trial attorney. Judge Woodruff gave significant deference to Mr. Sykes throughout this process. He was represented by counsel at the beginning of this process when he filed the motion to dismiss. When the motion to dismiss was filed, Judge Woodruff ordered us to, there was a period of time we had to submit affidavits. And then the day of the hearing, Mr. Sykes was called to the witness stand and gave further testimony. After that testimony, Judge Woodruff found that Mr. Sykes had moved to Tennessee with Mrs. Sykes. They lived together in her in-laws' residence. The affidavit submitted by Mrs. Sykes in this process showed that the parties were renting a storage unit here. The house was listed for sale and was under contract by early June, and the house closed in August. These parties—
That's the house in Missouri, is that correct?
That's correct, Your Honor. These parties abandoned the state of Missouri, and Mrs. Sykes' testimony was that Mr. Sykes had lost his job in Missouri and they needed financial help. They moved to Tennessee to live with her parents to get back on their feet. And then Mr. Sykes testified, and Judge Woodruff quotes it, that there were some problems in Missouri, but they came to Tennessee to try and work on their marriage. And it was in Tennessee that Mr. Sykes left the marriage. It was in Tennessee that he sent that text message. It was in Tennessee that he was served. So all of those things being considered by Judge Woodruff at the motion to dismiss, he properly found subject matter jurisdiction. The parties moved here. They changed their vehicle registration. They changed their driver's license. And the court later on, the Missouri divorce complaint was submitted into evidence at the trial. And Mr. Sykes, when he filed that Missouri divorce complaint, stated unfactual statements about his residence. And that was part of the finding by Judge Woodruff. In fact, that it was in bad faith, which I'm all over the place here, but that goes into why Mrs. Sykes was awarded attorney's fees on the jurisdiction issue. Mr. Sykes had filed this in Missouri and claimed he had been a resident of Missouri for 90 days. And then the judge looked at the driver's license, the Missouri driver's license that was reissued when he moved back. Mr. Sykes meant to come to Tennessee. He changed his driver's license. And then he, after being served in Tennessee, moved back and tried to, quote unquote, rip the rug from under my client's feet. So subject matter jurisdiction is proper. The acts occurred here while they were residents of the state. The same argument goes for jurisdiction over the children. The parties abandoned their domicile in Missouri and created a domicile in Tennessee. So when Judge Woodruff investigated the question of whether we had jurisdiction over the children, no parent lived in Missouri, no children lived in Missouri. So under subsection A1 of the statute, no other state had that. The only state that actually had jurisdiction, therefore, was Tennessee, where the parents and the children resided. That makes jurisdiction proper. a further analysis of that goes into inconvenient forum. Nobody had anything in Missouri. There was no residence in Missouri. There was no, Mrs. Sykes was employed in Tennessee. The parties were living here. All of their property, I think except a fishing boat and some fishing poles, was in Tennessee in a storage unit and in the parents' garage and in their house.
Were the children enrolled in school in Tennessee at the time that this all occurred?
The children were enrolled. The children, Your Honor, were too young to be enrolled in school at the time. They did look for, and I believe find, some daycares for the child. And then their oldest child began, I think, pre-kindergarten the following August is when that occurred.
I thought there was some specialized treatment plan that had been developed in Missouri that the Tennessee authorities utilized in working with one of the children. Am I confusing my cases?
No, Your Honor, that did occur, I believe, and if recollection serves, that occurred the following year.
Okay.
And that was also, quite frankly, part of the contempt on not returning the children. Mr. Sykes had the child in Missouri that following summer. My client allowed him to have the child for the summer, and their agreement was that he would bring the child back at the end of summer before school started. And we began requesting that he bring the child back in July, began asking for a date. And at that point, Mr. Sykes began playing games. He did not respond. He did not agree. In fact, he started arguing. We filed a motion to try and move the case along, filed a motion to set. And then when it became apparent that he was not going to return the child, and then in fact, school in Williamson County started and he still had not brought the child back, we filed the motion for a restraining order to bring this child back to Tennessee. My secretary had to go testify at this hearing about how we both emailed and mailed the order that was sent to him at the contempt hearing. When we got to the contempt hearing, he claimed he didn't know about the requirement to bring the child back. The Judge Woodruff, again, showed him, he was pro se at this point, showed him significant deference, gave him a chance to think about it. He instructed him that this is a civil contempt hearing and that he could be subject to incarceration. He passed our case to the heel of the docket. And then at the heel of the docket questioned whether Mr. Sykes wanted to continue the case or go forward. And Mr. Sykes waived his right to continue the case. He waived the option and he went forward with the hearing. And the judge affirmatively found that Mr. Sykes knew about the order to bring this child back. The judge, I think, acted very prudently. We were fixing to face a multi-state custody matter. And Mr. Sykes, again, there's no transcript of this record. Mr. Sykes didn't produce it. I believe I had a court reporter there that day. But the court was giving him significant deference. The court tried to give him a chance to even explain why he should be allowed to go back to Missouri and bring the child back. And Mr. Sykes did not answer that question well for the judge. And so when given the choice, the judge found the safest and most efficient way to make sure that this child came back from Missouri was to find Mr. Sykes in civil contempt for not bringing this child back. It was a violation of both the statutory restraining order and his ex parte order. And the judge, I think the judge found that Mr. Sykes was once again playing games with this court's orders. He's been alleging he never moved here, and clearly he did. He began alleging that it wasn't the end of summer yet because fall starts in September, so he wasn't going to bring the child back. He was making all these just very wild claims in this hearing, and the judge thought he was playing games, and he had control of this child in Missouri, and he wasn't going to bring him back. And Judge Woodruff had to make a decision to protect that child, and the restraining orders being violated and his ex parte order being violated, and the actual proof from my own secretary who sent this information to him. And then when Mr. Sykes began denying it, the judge even I mean, it was a civil contempt hearing. The judge asked to see his phone, and the email from the court and from my secretary, I believe, were both in his email registry. So he had not knowledge of these orders. And so that's why attorney's fees were appropriate in that situation as well. Mr. Sykes was playing games. It caused not only attorney's fees for my client, but also some significant concern. Mr. Sykes took their child with her permission to Missouri, and when he didn't bring or was refusing to cooperate to bring the child back in these domestic cases, that can be a significant source of worry. So Mrs. Sykes, I believe, we did all we could, and the judge made a prudent decision based on the orders to protect the child. So that really resolves it, Your Honors. That's why the judge awarded fees for the contempt. And then on the jurisdiction issue, that's why the judge awarded fees for that question of jurisdiction. Both those attorney's fees, by the way, were awarded under separate statutory grounds. I do know that we award attorney's fees in divorces as alimony and solido, but there were independent statutory grounds for the award of those fees as well. And to address that issue, the judge had me bifurcate in the morning of the trial. He had me bifurcate those attorney's fees out. Those fees were presented to the court. Mr. Sykes, again, being pro se, he does bear some burden of acting as an attorney because the fees were specified and borne out to the trial court during the course of the trial. Mr. Sykes at that time could have challenged or asked questions about those fees, and he did not. So my position on this appeal is that because the fees, this isn't a case where the judge says, submit your attorney's fees and I'll determine an amount at a later date. This was a,
yes, let me ask you a question. Doesn't the record reflect that you submitted affidavits of these attorney's fees?
Yes, Your Honor, I did.
And didn't the court ask Mr. Sykes whether he had any objection to the introduction of those affidavits?
I believe he did, Your Honor.
And then when you completed your examination, you brought these in through your client, is that correct?
That's correct, Your Honor.
And you questioned your client about incurring these fees, is that correct?
Your Honor, there probably were not significant questions to me by Mrs. Sykes, except to say, these are the fees that I've charged you for these expenses. And then I believe the judge asked me to break out those specific fees for the contempt and for the jurisdiction issue, but they were presented in open court, Your Honor.
And Mr. Sykes was given an opportunity to cross-examine at the trial, wasn't he?
Yes, Your Honor, he was.
All right, thank
you. Your Honor, in burning through the issues that were raised, the only other outstanding issue, there are two issues. One is that Mrs. Sykes is requesting her fees on this appeal, in part because Mr. Sykes is making the same arguments that he's already made. There's nothing new about them, and his credibility was significantly questioned by the court. But it was questioned because of documentary evidence, his driver's license from Missouri, the untrue, charitably stated the untrue statements in his Missouri divorce complaint. So she is requesting her fees on appeal. And the final challenge and the issue raised by the appellant was the division of the marital estate. And again, this is an issue that Mr. Sykes, and representing himself, brought on himself. When the court reviews the record, you'll see that it's during his case in chief that he is cross-examining my client, that he begins asking about the wedding rings, and he begins asking about these marble collections. Mr. Sykes on his own didn't put forth any proof on his case in chief about the value of these things. It was almost a gotcha question. Again, it was a pull the rug out from under her feet question that he thought he was going to, I don't know what he thought, but that's what he was trying to do. And you can see the judge's frustration. This is about 3 o'clock in the afternoon for a full day of trial, and he begins bringing up these other issues. On the marble collection, my argument is that Mr. Sykes failed to bring any competent proof on his own. And the range of values testified by Mrs. Sykes were from, I've never been able to sell anything, which is 0. And then she threw out a wild number that she had borrowed on a credit card. And then the judge reimbursed her because Mr. Sykes took her wedding ring and sold it. And there's testimony in the record about him selling that wedding ring. Again, Mr. Sykes represented himself pro se. We agreed orally to the division of this estate at the beginning of the trial, and we reserved specific issues which we talked about. Specifically being that Mr. Sykes took my client's 401k to purchase his new Jeep and paid the taxes on it. That issue was reserved, and I believe Judge Woodruff properly divided the marital estate considering the facts presented by Mr. Sykes and Mrs. Sykes. Thank you, Your Honors, for your time.
Thank you very much. We will hear the rebuttal of the appellant. I think you're muted.
Yes, sir. Sorry about that. I'd like to touch on the one issue that I didn't really touch on that the opposing counsel just did, which is the distribution or the division of the marital assets. That's really where, and you can see from both of our Rule 7 statements that there are several instances where the record, I think both of us can agree that the record is silent as to what an amount is that those items are worth, or there's significant dispute. The appellant contends that the trial court erred in firstly allowing them to agree upon a division and then granting what the court termed or what opposing counsel termed an equalizing distribution, which ultimately amounted to a $9,900 judgment against Mr. Sykes for representing mostly the appellant's vehicle and the sale of the wedding ring for $4,000. The court heard and accepted that division of assets from the outset of the proof, and Mr. Sykes, it's clear in the record, was under the understanding that he was agreeing to a certain division of assets and that was what was going to be done. I don't believe that the record reflects he truly understood what an equalizing distribution was going to be, and there was never an opportunity taken to explain that to him. The biggest issues that come from the trial court's ruling, in our opinion, is that the court took the wife's separately owned automobile and said that it was offset. The value of that was offset by the husband's collection of guns and hunting gear. However, there's never any mention from either party as to what the value of that hunting gear or fishing gear is. It's simply similar to some of the other comments that are made, or a little bit offhand from both parties regarding what assets they had. There's never a testimony to what the value is. However, the court specifically finds that it offsets the value of the wife's vehicle and any equity that was in it. The wife then further testified that she had this craft making hobby that she had realized over the years from selling from that craft making hobby, which is the glass and marble collection, about $2,500. Well, the court took that $2,500 and attributed that value to that asset, essentially. However, on mother's own testimony, which she's allowed to place a value upon her own property, she said that that collection itself was valued between $25,000 and $30,000. Now, Mr. Thorrington did a good job of clearing that up on his redirect of her, and it was, she kind of circled back around to say that it was the debt that was placed on the credit card. However, her original statement was very clear that that was the valuation. If the court took that into consideration and even attributed half of that, it would account for most of what was left of, or almost all, if not all, of the judgment rendered against Mr. Sykes. There are other issues regarding selling of property that was Mr. Sykes, that was separate property before the marriage, that was not attributed either. And I'll leave it at that, Your Honors. Thank you.
Gentlemen, we appreciate your argument. We appreciate you again participating by Zoom. We will endeavor to, we'll take this matter under advisement and endeavor to get you an opinion regarding this matter at our earliest opportunity. Anything we need to take up, Ms. Angie, before we recess?
No, Your Honor.
All right, you may recess until the call to the next case. Thank you again, gentlemen.
Thank you for your time.
This honorable court is in recess until 10 a.m.
Thank you.
Thank you.